All rights that have been mentioned are territorial. That is, they apply only in the country in which you have applied for those rights. So, if you already have or expect to have a market or markets in other countries or manufacture abroad, you should think seriously about applying in those countries also. Laws vary from country to country, but the various aspects of intellectual property are broadly similar. There is an ongoing worldwide movement towards harmonization of national laws designed to ease trade between countries and encourage the inward transfer of essential and innovative technology. Without such rights, an individual is likely to have the results of his efforts and dedication stolen by others. Countries in need of that technology also suffer if such rights are not available and enforceable, because investment will not be made without that protection. Also remember that licensing agreements involving such rights often embrace other vital intellectual property, such as know-how. To obtain equivalent foreign rights, you can apply directly for national patents and other intellectual property protection. However, there are also several international and regional treaties which can make applications for protection easier and which may be available to you. Always bear in mind that legal protection may be derived from the registration of intellectual property rights. They are subject to national law, and an infringer can be sued before the national court in the country where the infringement took place for, amongst other things, compensation, damages, or confiscation and destruction of the goods. In some countries, there is a judicial specialization for intellectual property, with dedicated courts judging in civil and criminal intellectual property cases. When you apply for a patent or want to register a trademark or GI, should you seek professional help or do it yourself? Provided that an applicant has his residence or place of business in a country concerned, he doesn't need to be represented. Such an applicant may, however, be represented by a patent or trademark attorney. A patent or trademark attorney is qualified to deal with intellectual property matters and is usually registered with a recognized professional body. It is certainly advisable to obtain professional help as soon as possible. Wrong wording used in the application may render the whole or part of the application useless, so it makes more sense to have it drawn up correctly to give it a better chance of success. If you want to protect your innovation, your products, or your company's reputation, and make the most of its business potential, it is important that you take advantage of the valuable protection and scope for effective enforcement that is available. If you think your innovation, creation, or name is worthwhile and something that you can profit from, it is almost certain that your competitors will think so too. And at the end of the day, you should be the one to receive the financial rewards for what you have achieved. So don't forget to protect your intellectual property rights. They may be crucial to your success.